People create wills so that when they die, they can leave their property to whom they choose. But what if a government regulation prevented a person from devising his land to his children? In Babbitt versus Youpee, the Supreme Court was presented with that scenario and ruled on whether a section of the Indian Land Consolidation Act was unconstitutional. In the 1800s, an Indian land program allowed tribes to give communal Indian land to individual tribe members. After generations of tribe members giving portions of land to their children and grandchildren, many parcels became extremely fractionated. This meant that a few acres of land may be owned by hundreds of people. This extreme fractionation made productive development impossible. To remedy this problem, Congress adopted the Indian Land Consolidation Act in 1983. Section 207 of the Act prohibited tribe members from devising fractional interests of land to their heirs. Instead, fractional interests would escheat or be transferred to the tribe. In Hodel versus Irving, the court found that this regulation amounted to a taking without just compensation. Congress then amended Section 207. Among other requirements, the amended section only allowed a party to devise a fractional interest in a parcel to someone who already owned a fractional interest in the same parcel. In 1990, William Youpee, a member of the Sioux and Assiniboine tribes, died. Youpee's will devised interests to various parcels of land on reservations to his children. Each interest was only devised to a single child. However, none of Youpee's children owned a fractional interest in the parcels that they were given by their father. Therefore, under the amended act, each of Youpee's children's interests in the parcels would escheat to the tribes. Youpee's children sued Bruce Babbitt, Secretary of the Interior, claiming that Section 207 violated the Fifth Amendment by effecting an unconstitutional taking of private property without just compensation. The district court granted injunctive relief for the Youpees. Babbitt appealed. The Court of Appeals affirmed. The United States Supreme Court granted cert.